you fire an employee for trashing your company on Facebook? That's the key question in what could be a groundbreaking case for labor law and social media law. Social media law, that's a whole new realm. The National Labor Relations Board is accusing the company American Medical Response of Connecticut of illegally firing an employee for criticizing her supervisor in posts on the Facebook website. The government agency claims the dismissal violates federal law. Joining us now from Washington is attorney Seth Berenzweig. He specializes in federal labor and employment law and has been named a top attorney by Washington Magazine and a legal elite by Virginia Business Magazine. So, Seth, congratulations on that. Take us through this here, because it would seem to me if you post nasty things about your boss or about your company online, it's a public forum. They would have recourse to let you go.
Well, this is a huge development that just happened a couple of days ago. The National Labor Relations Board announced that it's prosecuting a lawsuit against the Connecticut company because it terminated this individual for having these comments on Facebook. And it's very interesting because the National Labor Relations Act does restrict companies and their ability to discipline and terminate employees for freedom of speech, for work-related speech related to the terms and conditions of employment. Ironically, this individual had comments posted on the internet that really were very derogatory in nature, referred to her supervisor as a psychiatric patient, and ironically this kind of speech, and this will be an issue at the January hearing coming up, it really appears that this speech may very well not be protected under federal law.
I mean, Seth, where do you draw the line? I mean, what if this person had printed up a flyer or put around a petition? Where would that fall under the law?
Well, you know, that would be a little bit different than the instant case, because now in this case we're talking about internet posting and blogging, but it generally relates to the same issue under the National Labor Relations Act, because companies are restricted from taking disciplinary actions against people, employees, when they take actions that relate to sort of a freedom of speech issue regarding relating to the wages, terms, or conditions of their employment. But it's also interesting to note in this case that the company is going to have a problem because its internet posting site on the employment handbook was very broad, and therefore they're going to have to rely upon that as a basis for determination. And ironically, therefore, they may lose a case regarding facts and speech that may not be protected under federal law to begin with.
Seth, I don't know how familiar you are with Facebook, but each member has his own wall, and he can limit that to only his sort of group of friends that can see the wall. Right. So if it were the case that you printed some kind of comment on that sort of forum, it's only available to your friends and sort of blocked to the public, would that be a different case?
Well, it would be a different case, particularly if the people that got permission to go into your venue there on the internet were mostly people in the workplace. The hearing in January in this case will also involve a question of exactly that. How many people on this posting, how many people that had privity to this were people within the workplace? I would suspect that there were a number of people on there, just given the nature of Facebook and social media, that were not in the workplace, and therefore it's going to be harder for that person to say that this was internal office communications related to the terms and conditions of her employment.
I wonder, social media law, it's kind of weird to read that phrase, but is this a new a new kind of law, a new practice that a lot of lawyers could go into and make it a lucrative practice?
Well, I agree, and I think it's an important new area that's developed just based upon this case alone. For example, this is a wake-up call to companies throughout the United States, regardless of whether their individuals are unionized or not. The internet is the new water cooler, and that's where people are going to be communicating. So this is an important area of the law. I agree with you, and I think it's important for companies to really update their employee handbooks and policies, because if they don't do it, then they're really going to be giving up a lot of their ability and agility to be able to take care of that kind of an issue.
Definitely finding our way through this one. Hey, Seth, thank you so much. Seth Berenzweig.